All right. Kathy, can you just confirm that you can see my screen, please?
Yes, I can see your screen.
Awesome. Thank you so much.
Sure.
All right. So the title of our presentation is The Small Business Owner's Guide to Paid Leave. And what we're going to cover in here are not only all the information you need to know about the Connecticut Paid Leave Act, but also the Family and Medical Leave Act, because there have been some pretty significant changes that just went into effect on January 1st. And we want to make sure that you're aware of those as well. So we'll talk about the program. We'll talk about FMLA and Connecticut paid leave, keeping in mind as we're going through that they are two different laws. So they certainly are very much intertwined, but they are two entirely different laws with different requirements. We'll talk about implementing the Connecticut Paid Leave Act as well as implementing Connecticut FMLA. And we will leave you with some additional resources where you can gather more information and of course have time for Q&A. So first, we'll just start with a brief overview of the Connecticut Paid Leave Authority. The Connecticut Paid Leave Authority is the quasi-public entity that oversees the Connecticut Paid Leave Program. And we have 5 main areas of focus. The first being outreach and engagement. So making sure that everyone who's impacted by this program understands their obligations and also benefits from it. We develop the policies and procedures needed to run the program. We established the trust fund contribution rate and receive contributions. Now, the rate of contributions from employees is set by the statute. So when we say we establish the trust fund contribution rate, we can lower it, we cannot increase it. We also approve and audit private plans. That is for employers who choose to self-insure with a private plan as opposed to participating in the state plan. And there are specific guidelines and regulations if your business is interested in doing that, which we do not cover in this webinar, but there is plenty of information about that on our website. And we administer claims for paid leave benefits, which began on January 1st, so just a couple of weeks ago. Just some key dates looking back. In November of 2020, we opened our employer registration portal, and we have asked all businesses with 1 or more employees in the state of Connecticut who are covered by the program to register with us. These businesses deduct 0.5% from their worker wages, and we began taking those contributions in for first quarter of last year. So January 1st, 2021 is when those deductions were to begin. Now, quarterly, the businesses remit those to us here at the Paid Leave Authority through our online portal. There is a 30-day grace period after the end of the quarter. So the next due date, if you will, is January 31st, which would cover 4th quarter, so October, November, December of 2021. Starting on December 1st, we opened our application portal. And folks who knew of qualifying events that were going to be happening on or after January 1st were able to begin submitting applications. And then on January 1st, we did begin issuing benefit payments for those approved claims. Now, you'll see the note in italics down there at the bottom, which is really important to note. The Department of Labor has authorized a catch-up period, which goes from now through March 31st. And that is for employers who may have missed taking contributions last year. For this 3-month period, those businesses are allowed to take an additional 1% deduction from employee paychecks. So a total of 1.5% to try to make up for as much of those missed deductions from last year as possible. After March 31st, it does have to revert back to the 0.5%. And in order to take anything additional, the business would have to get special permission from the Department of Labor. Now we'll talk about who's covered by the Connecticut Paid Leave Program. And essentially most businesses in Connecticut are covered if they have 1 or more people working in the state. That does include nonprofits and private sector employers with a unionized workforce. Now, if you're a sole proprietor or you're self-employed, you are not required to participate in the program, but you may opt in if you would like to. If you choose to opt in, you do have to stay in the program for a minimum of 3 years, but everything else remains the same as it would for any other contributing employee. So the contribution would be 0.5% of self-employment earnings, and that individual would be able to apply for benefits just as anyone else who is contributing to the program can. We do have some exclusions, and that includes employees of the federal government, state of Connecticut employees, except as to covered public employees, which we'll address in just a moment what that means. The same goes for municipalities and local or regional boards of education. They're excluded unless they have covered public employees. And employees of non-public elementary and secondary schools are also excluded. Additional exclusions include railroad workers, folks who work for the government of another state, employees of sovereign nations, which of course here in Connecticut includes the employees that work at the 2 casinos, tribal casinos, employees who are engaged in interstate commerce, which would be truck drivers who might live in work in Connecticut, but live in another state and therefore not pay income tax in Connecticut. And lastly, spouses of active duty military who have opted to continue paying taxes in their home state instead of in Connecticut, where they're currently deployed. Now, I mentioned a couple instances in which some entities might have covered public employees. So what that means is non-unionized employees of the state of Connecticut, so they are considered covered public employees under the Connecticut Paid Leave Program. Unionized employees of the state who collectively bargain to be included in the program. And then in the case of municipalities and local or regional boards of ed, if the unionized employees collectively bargain to be included, then all of the employees, including the non-union employees, would be covered by the Connecticut Paid Leave Program. And you can see the definition of municipality down there at the bottom of the screen. It's pretty extensive, and it includes not only what we would normally think of like towns and cities, but it also includes things like tourism districts, flood commissions, housing authorities, etc. Now, I mentioned briefly sole proprietors, independent contractors, self-employed. If you pay self-employment taxes as defined by the IRS, you are not an employee and therefore you're not required to participate in the program. But as mentioned, you can choose to enroll if you would like to do that. The only caveat being you must stay enrolled for at least 3 years if you decide to do that. You contribute at the same rate as everyone else. If you're a sole proprietor and you also have employees, even if you choose not to opt into the program for yourself, you do have to take those contributions and remit them on behalf of your employees. And lastly, if you receive a W-2, you are then considered to be an employee and you would have to deduct and contribute for yourself, even if you were the owner or an officer of the company. Now, the life cycle of the contributions. So employees deduct the half of 1% of wages. Those contributions are post-tax and they're based on the wages as calculated for FICA. And they are capped at the Social Security contribution limit, which this year went up to $147,000. So regardless of how much an employee might make above that $147,000, their max contribution amount would work out to be $14.13 per week or $735 per year. So the employee remits those contributions quarterly. We receive the contributions and we validate that they are correct against data we have from different state agencies. We deposit those contributions into the Paid Leave Trust Fund, and that trust fund is the source from which benefits are currently being paid. Now, we're going to get into the differences between FMLA and Connecticut Paid Leave. Remember, and at the risk of sounding like a broken record, because you will hear me say it several times throughout the presentation, they are two different laws. We understand it's confusing because they are so intertwined, but the laws provide different things. And so FMLA provides job protection, but it does not provide income replacement. So FMLA stands for the Family and Medical Leave Act. There's a federal FMLA as well as a Connecticut FMLA. And both of those laws allow for an employee to take job protected time away from work to take care of certain family and medical reasons. Both laws do state that that leave is unpaid. However, some employers do adopt policies to provide for income replacement. A common example is maternity leave. Some employers offer paid maternity or parental leave. It's not a requirement under FMLA, but again, some folks do opt to do that for their employees. Many employers also will either require or permit employees to use any of their accrued PTO, whether it be sick leave, vacation leave, any other kind of PTO, while they're out in order to have some form of income replacement. As I mentioned, the law has changed pretty significantly as of January 1st. Here are the big changes to the law. There is no longer any hours worked requirement for eligibility. So previously under Connecticut FMLA, in order to be eligible for job protection, a person had to work for at least 1,250 hours in the past 12 months. That is no longer a requirement. Which leads to the second change, which is that job protection attaches after a 3-month period of employment, not a 12-month period of employment. Connecticut FMLA now applies to businesses with 1 or more employees. Previously, that was 75 or more employees. So we know that there is definitely a huge segment of our employers in the state that now have to learn about FMLA where they previously were not subject to it. There are also some expanded reasons for leave, including a family violence leave provision. And there is an expanded definition of family, which we'll get into momentarily. Again, just kind of looking at the FMLA guidelines side by side, what was versus what is right now. So now if you're a business with 1 or more employees, you are subject to Connecticut FMLA. You would have to provide job protection after 3 months with no hours worked requirement. And the length of time that someone is eligible for job protected leave under FMLA has also changed. It was previously up to 16 weeks in a 24-month period. It is now up to 12 weeks in a 12-month period. Only exceptions to that are military caregiver leave, so caring for a military family member who is injured in active duty, was and remains at 26 weeks of job protected leave. And then a new provision is that there are an additional 2 weeks that may be available for a patient who experiences incapacitation during her pregnancy. Lastly, employers previously could require their employees to use all of their accrued PTO. So if someone was going out, say, for a surgery, they had 4 weeks of PTO accrued and their doctor told them that they were going to need 4 weeks to recover, the employer could say, you need to use all 4 weeks of your PTO if you would like to receive payment for this timeout. Now, starting in 2022, the employer can still require the employee to use their accrued PTO, but they must allow them to keep up to 2 weeks if they would like to for use later on in the year. So in that example that I just gave, if someone had the 4 weeks of accrued PTO and their doctor said they had to be out for 4 weeks, the employer could require them to use 2 of those 4 weeks, but would have to allow them to retain the additional 2 weeks. Now, if the employee said, you know what, I want to use all 4 of my weeks so I can make sure I get paid 100% while I'm out, that's fine. It just can't be, the employee can't be compelled to do that by the employer. Now, Connecticut paid leave provides income replacement when someone is out for those qualifying reasons, but it does not provide job protection. So the really important takeaway from this is that if an employee is going out on leave, there's sort of 2 questions to ask yourself. And one is this employee's job eligible for job protection under FMLA? And also, how is this employee going to get paid while they're out? And that's where the CTPL piece comes in. So the acronym CTPL, you'll hear us use it to refer to the law itself, to the program, and also to ourselves here at the agency, at the Connecticut Paid Leave Authority. Connecticut Paid Leave created a source of income replacement benefits for eligible employees who cannot work for certain family and medical reasons. And again, it does not provide job protection. You also may hear it referred to as PFML, or paid family and medical leave. We try to use the CTPL just to create more of a distinction between paid leave and family and medical leave. So we have 6 different reasons that someone can apply for, you'll see it says leave or receive benefits. And the reason that we wrote it that way is the reasons you can apply for job protected leave under FMLA are the same reasons that you can apply for Connecticut paid leave benefits. The first is called medical leave. That's leave that a worker would take to receive treatment for or recover from their own serious health condition. And serving as a bone marrow or organ donor does qualify as a serious health condition, as does pregnancy. We also have bonding leave. So bonding refers to the emotional and physical attachment between a parent and a child. And bonding leave is taken for a worker who is spending time with a new child that has entered their home through birth, adoption, or foster care. Both mothers and fathers may take bonding leave. and it can be taken at any time in the 12 months immediately after the child's birth or placement in the home in the case of adoption or foster care. So a parent might want to take that bonding leave immediately after the child's birth, adoption, or placement in the home, or they might want to wait until the child is 6 months old and then take that time, and either is fine. In the case of adoption or foster care, bonding leave can also be taken for the time needed for pre-placement activities. The third type of leave is caregiver leave, and caregiver leave is taken by a worker to provide physical or psychological care or comfort for a family member who's experiencing a serious health condition. So this might be to be with a family member who perhaps has been diagnosed with cancer and is undergoing chemotherapy treatments. One note just about pregnancy as it relates to medical leave and bonding leave, because we do get this question a lot. The time that might be taken during a pregnancy is considered medical leave, and then the time taken after the pregnancy and the typically 6 to 8 week recovery period after a birth is considered bonding leave. So they are two different types of leave. Then we have family violence leave. This is unique to Connecticut, and it provides for up to 12 days in a calendar year. So 12 days of the 12 weeks that are allowable in a calendar year can be used for family violence leave. That can be taken by an employee who's experiencing family violence, and they could use that time to seek medical or psychological care, to work with a victim services organization, to relocate, to attend court proceedings, etc. The last two types of leave have to do with military members. One is called qualifying exigency leave, and that's leave that a worker would take if they were notified that their spouse, child, or parent who was on federal active duty had been notified of an impending call to order. So, for example, if someone's spouse was notified of a call to duty, they might need to take qualifying exigency leave to arrange for alternate childcare after their spouse was deployed, or to visit their lawyer to get some legal documents in order, or something like that. And then the last type of leave is called military caregiver leave. And that is leave that is leave that is taken for a person who has a family member who was injured during active duty in the armed forces. Okay, just want to answer a quick question that came in. How many weeks could a pregnant woman who then gives birth technically qualify in total with medical and bonding leave? So the total could be 14 weeks, and that would be the 12-week total that's allowable under Connecticut paid leave, and the additional 2 weeks if the woman experienced incapacitation during pregnancy. So typically, or in all cases, when you're combining medical and bonding leave, it's still a 12-week maximum. So it doesn't double up. It doesn't become 24 weeks. Still 12 weeks, with the caveat that there could be that additional 2 weeks for incapacitation during pregnancy. All right. Now, understandably, we've been getting a lot of questions about COVID and Connecticut paid leave. So if someone is exposed to or diagnosed with COVID, that in and of itself is not considered a serious health condition. And a serious health condition has a legal definition, which can be found on our website, but which I also have down here at the bottom of the slide. So if being exposed to COVID or being diagnosed with COVID led to one or more of the elements of a serious health condition, for example, if the exposure to COVID resulted in an overnight stay in the hospital, or if it incapacitated the employee or the employee's family member in the case of caregiver leave for more than 3 consecutive days, and that included ongoing medical treatment, such as prescription medication, multiple visits with a healthcare provider, etc., or it resulted in or exacerbated a chronic condition, then that, if it's considered a serious health condition and the healthcare provider provides documentation as such, that could qualify for Connecticut paid leave. In the case of someone who has COVID, maybe has milder symptoms and has to stay home, rest, use over-the-counter medications, that would not be considered a serious health condition. Well, when we talked about caregiver leave, I want to clarify what relationships that applies to. So under the Connecticut laws, an employer can take caregiver leave for a parent, a spouse, a child of any age, a sibling, a grandparent, a grandchild, or an individual related by blood or affinity. So what does that mean, related by affinity? Related by affinity basically means if there's a close personal bond that is like one of the family relationships listed, regardless of if there's a biological or legal relationship. So here are a couple of examples. Say you have an aunt or an uncle who relies on the employee for unpaid care, and they maintain a relationship like the kind that you would normally see between a parent and a child. That would be considered related by affinity. A more common example might be an unmarried couple who live together. They maintain a familial spouse-like relationship. They share finances. Perhaps they have children together, but they're not legally married. That would be considered related by affinity as well. Now let's take a peek at the eligibility requirements. So we have federal FMLA on here just to provide a point of reference for anyone on the call who might have 50 or more employees. That is the threshold for federal FMLA. So if you don't have 50 employees or more, federal FMLA would not apply to your business. And federal FMLA is not undergoing any changes. This is, again, just here to provide a point of reference. So for federal FMLA, for someone to qualify for job protected leave, that person must have been employed for at least 12 months and have worked at least 1,250 hours in the 12 months immediately preceding their leave. For Connecticut FMLA, under the new regulations, if someone has been employed by your employer for at least 3 months, they are eligible for job protected leave under FMLA. There is no hours worked requirement any longer. For Connecticut paid leave benefits, so say someone is going out on leave, their employer establishes that they have met the requirement for 3 months of employment in order to have job protection. And now they're considering applying for Connecticut paid leave in order to have income replacement during that time away from work. They must have earned at least $2,325 in the highest earning quarter of the first 4 of the past 5 quarters. That's what we consider the base earnings period. That can be from 1 or more employers. So if you have a part-time employee, for example, and they work 2 or 3 part-time jobs, as long as they had met that minimum earning threshold from their covered employers, then they would meet that requirement. And then secondly, the person needs to either be currently employed and working in Connecticut, or if they're not employed, they were employed and working in Connecticut during the 12 weeks immediately preceding their leave. If it's a sole proprietor or self-employed individual, they also have a residency requirement. So sole proprietors have to be residents of Connecticut as well as having opted into the program. That residency requirement only applies to sole proprietors or self-employed individuals. Other covered employees, it does not matter if they live in Connecticut or not. They could live in Massachusetts. If they work for a covered Connecticut employer, then they would be eligible. Now, when we look at the summary of entitlements, so the length of leave or benefits available, under federal FMLA, there's up to 12 weeks in a 12-month period for all leave reasons, with the exception of military caregiver leave, which is 26 weeks. Under Connecticut FMLA, as it is now currently, the lengths of time reflect federal FMLA in most cases. So up to 12 weeks in a 12-month period for all leave reasons except military caregiver, which is 26 weeks. And then the 2 other considerations in Connecticut are that up to 12 days of the 12 weeks in a calendar year can be used for family violence leave under the under the Family Violence Leave Act. And there are those 2 additional weeks possibly available for incapacitation during pregnancy. Now, the length of benefits under Connecticut paid leave, there's up to 12 weeks in a 12-month period for all reasons, including military caregiver leave. So if you have an employee who's out on military caregiver leave, they may indeed be eligible for 26 weeks of job protection, but only 12 of those weeks would be eligible for income replacement under Connecticut paid leave. Under Connecticut paid leave, the 12 days of the 12 weeks can be used for family violence leave and receive income replacement. And the additional 2 weeks could also be available for income replacement for incapacitation during pregnancy. So we're going to get into implementing the Connecticut Paid Leave Act. And for that, I'm going to turn it over to Kathy because she's our expert on this. But I just wanted to take a look at the questions and answers and see if we can address any of those. So,
Jessica, just to let you know, I can't see any of the questions.
okay. All right. So I'll read them and Kathy, please feel free to jump in. One
Okay.
question is, can bonding leave be taken intermittently? Would you like to address that, Kathy?
Yes, bonding leave can be taken intermittently.
Okay. Kathy, correct me if I'm wrong, but it does depend on the employer's policies. Is that correct? If the employer typically permits that, then that would be okay under Connecticut paid leave. But if not, then they would not be able to do that. Is that the correct answer?
Well, what happens is that when a person applies for bonding leave, they need to notify their employer. And especially for a reduced schedule or intermittent leave, the employee needs to have a conversation with the employer that this is their intent, that they do plan on taking either intermittent or reduced schedule.
Okay, thank you, Kathy.
Sure.
Next question that came in, and sometimes we save these all until the end, but I thought it might be helpful for us to address the ones that have come in so far. Next question, Kathy, is how does an employee prove related by affinity?
Well, what happens is we ask employees to establish that relationship, and we do that through a form. We have a form which is called an affinity statement, where the employee would put down their name, address, their information, their case number, if they have one at the time. And then they would describe the relationship. For example, my aunt has been more like a mother to me, or my uncle is closer to me than, any family relative. And then the employee signs and dates the form. And what it is it's an attestation, which is the legal term, which means verification, that the employee is attesting, yes, this relationship does exist, and they're confirming that it is correct.
Okay, thank you. And can medical leave be taken intermittently?
Yes, of course, you have to have the appropriate documentation, which is the medical certification from the physician. And depending on the employee's conversation with the physician, they would determine the amount of the intermittent leave depending on the employee's medical condition and discussions with the healthcare provider.
Thank you.
Mm-hmm.
And our last question for right now, and then we'll let you get back to the presentation, is if an employee is eligible for Connecticut FMLA and federal FMLA, and normally the employer would have the employee exhaust their PTO, this is now overridden by Connecticut FMLA. Go ahead, Kathy.
Did I understand someone said, is it overwritten? Like, is that what the question is? How it works is that depending on the company policy, most companies have a policy that if you're out on leave, the first 5 days are PTO, which could be vacation, sick, whatever is written in the company policy. And once we would receive that information, because that's part of the administrative process, part of the information that we request from the employer is, for example, do you have any PTO policy when someone goes out on leave? And number two is, do you have a short-term disability policy that will be kicking in? So what we do as part of the administrative process when we process a Connecticut paid leave claim is the coordination of benefits with the employer. The employer provides us with the information, and then it's coordinated with Connecticut paid leave income replacement.
Thank you. And just to add to that, the change is that now under Connecticut FMLA, you cannot require your employee to exhaust all of their PTO if they do not want to. So if they have, like in my example, 4 weeks of PTO and they need to be out for 4 weeks, you can require them to use 2, but then you have to allow them to retain those other 2 if they would like to. If they say, no, I want to use all 4 of my weeks because I want to guarantee I'm going to get full income replacement, and I know that I will if I use all 4 of my weeks, then they can. But if they say, you know what, it's February and I'm having this surgery, but my daughter's getting married at the end of the year and I need to save 2 weeks so that I can attend all of her wedding activities, for example, you would have to let them retain those 2 weeks of PTO to use later on. And in that case, that's where they might apply to Connecticut paid leave for income replacement during those 2 weeks that they otherwise would not have any income from you. All right, so we'll let Kathy get back to the presentation, and then I will address other questions as they come in, or if I can't, we'll leave those for Kathy to answer live as she gets to the end of this. So with that, Kathy, it's all yours.
Thanks, Jessica. Great job. Morning, everyone. Happy Tuesday. What I'll be doing this morning is going through some of the administrative processes that are involved when an employee or worker comes to you saying that they're going to take, they've applied for Connecticut paid leave. So there are different sections of responsibilities, and I will be speaking to each of them. First of all, an employee, if they want to apply for Connecticut paid leave, they need to go to the Connecticut paid leave website and create an account. So that just contains basic information, name, address, phone number, email address, very basic information. As part of that process, then they will receive a pop-up saying, are you ready to file a claim now? So the employee has the option to file a claim right away if they have their required documentation. They can start the process, come back later, or they could just totally decide, all right, I set up my account today, I'll file my claim tomorrow. So that's the responsibility of the worker. The worker/employee is the one who initiates the process. As part of that process, the employee will receive what's called an employment verification form. And that is a form that they will be presenting to the employer. What that form asks is items such as verifying the employee's employment, their job title, their start date, and just basic information about the employer's address, who's the contact person's phone number. And it also asks for the contact person at the company, at the employer, for their email address. When you receive this form, it is very important to put down the email address of the person responsible for the leave management. The reason is that once a claim is approved, the employee receives an email saying your claim has been approved, here's your welcome kit, here's your documentation, here's what you need to do. There's also an email that will be sent to the employer, which includes the name of the person, the type of leave they're taking, whether it's caregiver, medical, there's no HIPAA, no personal information in this email, just the type of leave, the start and end date of the leave, and then the weekly benefit amount. The Connecticut Paid Leave Authority, their responsibility is with AFLAC. AFLAC is our claims administrator. They determine the eligibility. They review the supporting documents, make sure that the documents are in order, that they're signed, that they're for the appropriate, they look for any information that, for instance, if you're applying for a medical leave, and then at the bottom it says something about military leave, it's like, okay, wait a minute, we have to make sure everything is in alignment. So they review the supporting documentation, approve, deny claims, calculate and pay benefits. They monitor ongoing claims. By that, let's say someone takes a 4-week leave, and then they say, oops, I really need to take 6 weeks. So they would have a conversation with their healthcare provider, complete the additional paperwork required of course, notify AFLAC, and then notify the employer that there might be any changes, that there might be changes in the dates of the leave. Oops, excuse me. I feel like I'm going to sneeze. This is terrible. Connecticut Department of Labor. Let's say that for some reason, a claim is denied. Either the supporting documentation was never provided, maybe the person isn't eligible. If the person would like to file an appeal, they would do so directly through the Connecticut Department of Labor, and they would through the Department of Labor website.
And Kathy, just to interject, and I apologize, I should have mentioned this earlier, but Connecticut FMLA falls under the purview of the Department of Labor. So we provide education on this because, again, it's so intertwined with Connecticut paid leave. But really any and all questions related to FMLA ultimately will go to the Connecticut Department of Labor.
Yes, that is correct. Thanks for adding that, Jessica. Okay, so income replacement, Connecticut paid leave process. The worker goes online, start their claim. They also can call a phone number, which is through AFLAC, to initiate the claim if they choose to do so. They need to submit the supporting documentation to AFLAC so they can start with determining eligibility and processing the claim. So AFLAC would validate the salary. They have access and information from the Department of Labor data. They look at the documentation the employee provided, and they determine if the worker is eligible or not. If the worker is not eligible, they will notify them. And if for some reason, let's say a physician, and I'm just making this up, and if the physician submits the paperwork, say it's a month late, and the case is closed, they could request reconsideration, meaning, you know, it wasn't my fault, this happened, the doctor was out of town, could you reconsider my claim? So there is a process. If something like that were to happen, there are options for the employee. The thing to remember is that if that does happen, or if employees have any issues, they need to contact AFLAC directly. So AFLAC will review the supporting documentation and especially review employment verification. If documentation is missing, AFLAC will reach out to the employee via email, text, or by phone. And again, if the claim is possibly denied, AFLAC will notify the employee/worker and let them know what the next steps are for what's called reconsideration. Okay, so AFLAC calculates the benefits with the information they were provided. They take into consideration the leave and offsets for other incomes, such as short-term disability, paid time off, and that information would have been provided by the employer. AFLAC issues the benefit payments by electronic transfer or direct deposit, or stored value cards, also known as an e-card or a debit. It would be a debit card. Benefits are issued each Tuesday, 2 weeks in arrears. Now, just as a side note, this 2 weeks in arrears, we are in the process of changing it to 1 week in arrears. So just be on the lookout on the website in the next few weeks for more information regarding that. For example, how it is currently, benefits for the week of January 10th through the 14th will be issued on the 25th. And as I had mentioned, that will be changing shortly in the next week or two. The worker is responsible for notifying AFLAC of any changes. For example, the start and end date. Perhaps the start date is delayed. Perhaps the end date is sooner or later than the employee anticipated. If there's other income that the employee is receiving, for example, if someone is on workers' compensation or unemployment benefits, they're not eligible for Connecticut paid leave. If a worker is taking intermittent leave, they need to provide frequent updates about the leave usage, which means they would need to let AFLAC know. And of course, they would need to keep their employer up to date as far as any intermittent leave or schedule changes. So here's an example of the Connecticut Paid Leave Employment Verification Form. There's a section the applicant has to complete. They sign it. They give it to the employer. Once the employer receives the form, you have 10 days to get that back to AFLAC. Now, it doesn't show on this form. This is just a template. There is a phone number and a fax that is provided under the employer information where it reads instructions to the employer. So there is an email and a fax number for you to either fax or scan and then email the form to AFLAC. So we need the employer name. As far as the various tax numbers, we only need the FEIN, which is the Federal Employer Identification Number. We really don't need the tax ID and the SIC NAICS code information. We've had feedback from employers that it's difficult to provide all this information. And what we do as part of the process is we take feedback from employers as to how we can make things easier for them and for the employee while they're going through this process. It's very important to have a contact name, phone number, and email. So let's say we have a question. The person originally applied for continuous leave, and now all the documentation is showing intermittent. Or there's a discrepancy in the date of hire. Or the person has told us they're terminated and has not canceled their paid leave application because they're collecting unemployment, say. So whatever questions we may have regarding the claim, regarding the employee status, if we have your name and a contact email, it just expedites the process for everyone. It makes it more streamlined. Okay, benefit calculations. Minimum wage workers receive 95% of their base weekly earnings. Those who earn above minimum wage have a slightly different benefit calculation. The maximum weekly benefit is capped at 60 times the minimum state wage, which is currently $13. So 60 times 13 is $780. So that is the maximum that a person would receive under Connecticut paid leave. A worker may never receive more than 100% of their normal wages, and this is to be kept in mind when coordinating PTO, short-term disability, and Connecticut paid leave. So here is an example of what's called a benefits estimator. This is located at the ConnecticutPaidLeave.org website. It's a very efficient tool that if you would need to know and like to estimate what one of your employees would receive while they're out on leave, you select the pay frequency. If you get paid weekly, monthly, however your pay, whatever your pay cycle is, and then enter the gross earnings of the individual, and you'll receive, and you can see it, on the bottom left-hand corner of the page, an estimation of what the employee would receive or what the benefits would be. Okay, so what we have here are 4 different examples to provide you with further education as to how to coordinate, say, PTO with Connecticut paid leave. So scenario number 1, the worker has no PTA to use for Connecticut paid leave. So the worker would receive the full amount for the full period of leave. So say, for example, they were approved for 8 weeks of leave and there's no PTO. The employee would receive the full benefit of Connecticut paid leave for the 8 weeks that they were out. Scenario number 2, the worker does have enough PTO to cover the entire leave. So some companies, which we found out, have policies that, okay, we have our own absence management policy where any one of our employees is out, we pay 100% of salary the time they're out. So if someone is receiving 100% of pay from their employer, there are no CTPL benefits that are going to be paid. Because the thing to keep in mind is no one is to get more than 100% of their regular pay. Scenario number 3, the worker has PTO to cover part of their leave. They have some PTO. So the Connecticut paid leave benefits will start after the PTO has been exhausted from the employer. Scenario number 4, the PTO is less than the worker's regular pay. So there would be a coordination of benefits between the employer and Connecticut paid leave to make up any wage differences. Employees need to keep in mind they're never going to get more than 100% of regular pay. If by chance, sometimes there's a timing issue and we receive PTO information after their CTPL benefit, say, has started, we do have an overpayment process in place. And once that's identified, then we will work with the employer and we will coordinate the, how that money is to be returned. Okay, what do your workers need to know? So what's going to happen is that your workers are going to be coming to you for information as far as, okay, what do I do? What happens? Who do I call? Who do I need to notify my supervisor in addition to, say, if you have an HR department, like how does all of that work? So they need to have a conversation with their employer that they need to take leave. The worker can and then find out from the employer, are there any rules about such use of time? For example, do you have to use all your sick time before your Connecticut paid leave starts? A big one is, the large question is, do you offer a short-term disability policy? If so, does the policy state that the worker has to exhaust their PTO and Connecticut paid leave benefits before short-term disability will start? Or will the short-term disability policy reduce the amount it pays because Connecticut paid leave and PTO is being paid? How you find out that information, you'll need to pull your short-term disability policy, take a look at the plan document and see what it says, so that however it's written in your plan document is how you need to administer your plan. Okay, implementing Connecticut FMLA claims. Now again, Connecticut FMLA is handled by the Department of Labor, but we're providing this information as part of Connecticut paid leave training. So this is additional information for you to use, and it's very valuable in addition to the Connecticut paid leave information being provided. So the worker notifies employer about the need to take time away from work. They submit the application, provide the employer with supporting documentation, and also have a conversation with the employer. What do I do as far as attendance and call-in policies? Like, what are the company policies? The employer should have an established leave policy in place, guiding employees along. Okay, here's what you need to do. You need to notify this person, your supervisor, and just outlining the process so that the employees know what they need to do. You need to process leave requests for Connecticut FMLA. There is a poster, Connecticut FMLA poster that, I know a lot of people are working remote today, but there is a poster available if you have any type of newsletter or anywhere on the company website that you could post this information. The employer is responsible for monitoring the leave usage. So whether it's through Excel or through payroll and running reports, there is a requirement by the employer to monitor when the employee's in the office and when the employee takes time off for leave. The employer manages the worker return to work and also refrains from discriminating or retaliating against workers for FMLA usage. Again, Connecticut Paid Leave Authority has no official responsibilities related to Connecticut FMLA. However, as part of our training, we do provide this information. Connecticut Department of Labor is responsible for administering the Connecticut FMLA. They provide guidance to workers and employers about Connecticut FMLA. They also investigate complaints and any denials or discrimination concerning Connecticut FMLA claims. Okay, job protected leave process. Again, worker notifies the employer they need time off. The worker is not required to use the term FMLA. Ideally, employees need to give employers 30 days in advance for the leave, if it is foreseeable. If it is not foreseeable, such as an emergency, they need to let the employer know as soon as possible. The employer determines if the worker is eligible for Connecticut FMLA and notifies the worker if they need to provide any additional documentation. The employer has 5 days to notify the worker of eligibility and also provide what's called a Notice of Rights and Responsibilities, which is also located on the DOL website. Please note this is not the leave approval. The worker provides the required documentation, whether it's a medical certification, adoption documents for adoption, military records, whatever pertains to that particular leave. The worker has 15 calendar days to provide the documentation. If they experience any difficulty in obtaining these documents, the employer should give the worker some additional time. The employer will notify the worker if the leave is approved under CTFMLA. The employer has 5 business days once it has received the required documentation supporting the leave request. The employer must notify the worker if they are required to use paid leave accruals, how the worker needs to report in, when and how often, and if the worker will need to provide what's called a fitness for duty before returning to work. Just as a side note, that fitness for duty usually comes from the healthcare provider. The worker reports to the employer when they actually take the leave. And again, the employer needs to track the leave usage to ensure that the worker does not exceed the 12 weeks. The employer returns the worker to the job the worker held before the leave. The worker has the right to return to the same job with the same terms and conditions. The employer cannot insist an employee be 100% fit for duty or totally recovered. The employer must also consider American with Disabilities Act and the Connecticut Fair Employment Practices Act and the obligations thereof. Designating leave as FMLA. Sometimes workers don't want the leave to be designated as FMLA. And in all circumstances, it is the employer's right and responsibility to designate that time off, which qualifies under FMLA as FMLA leave, even if the worker does not ask for it. This protects you, the employer, and this protects the employee. Overview of leave laws. There are laws providing job protected leave. Federal FMLA applies to employers with 50 or plus employees. Connecticut FMLA, before 1/1/22, this law applied to employers with 75 plus employees. Effective 1/1/22, this law applies to employers with 1 or more employees. Workers' compensation is for covered on-the-job injuries or illnesses. Americans with Disabilities Act, if you have 15 or more employees. The leave may be a reasonable accommodation. Pregnancy Disability Act, 15 plus employees. Connecticut Fair Employment Practice Act, 3 plus employees. Now the laws providing income replacement during leave. Connecticut Paid Leave Act with 1 or more employees working in Connecticut, effective 1/1/22, and workers' compensation for covered on-the-job injuries or illnesses.
Thanks, Betsy. So we just want to leave you with a couple of additional resources, and then there are a few more questions that we'll answer. So we have quite a bit of information available on our website that can be downloaded and given to employees to help explain this program and process to them. We have an employee rights poster, a rack card, a paycheck insert, employee fact sheet, and then for employers, we have an employer toolkit and a human resources toolkit. which go into more detail about some of the different things that Kathy and I reviewed today. So you can download any of those from the website. Also, for any FMLA related questions or documents, if you visit the Connecticut Department of Labor website, specifically what's highlighted there in yellow, they have a whole page with the new FMLA guidance and downloadable resources in terms of the forms, eligibility, FAQs, etc. This is just an example of some of the different downloadable forms that they have available. I know in some of our previous webinars last year, folks were asking if those were available. So just wanted to show you that they are in fact there and able to be downloaded for your use. If you have questions related to Connecticut paid leave, we do not have a call center, but we do have a contact us portal at our website. So if you go to Connecticut paid leave, ctpaidleave.org, and you click on the contact us tab, you can fill out some information. It will go to our contact us center. If you would prefer to speak to someone as opposed to emailing, that's absolutely fine. You can indicate that on your form as your preferred contact method. And one of our specialists will call you typically within 48 hours. We also have several hundred frequently asked questions on our website, and we have tons of different videos, both for employers and employees to help with this process. Some are embedded in our website and some are available on our YouTube page. And so with that, I will stop sharing. And Kathy, just a couple of questions that I'd like for you to answer. One question is, what happens to employees who pay for AFLAC? Does this have anything to do with Connecticut paid leave, and do they cancel any policies they have with AFLAC?
Okay, that great question. That would be the responsibility of the employee to go to their AFLAC representative, look at their policy, and compare it with what they have under Connecticut paid leave. It's a personal decision. So I would recommend that they get in touch with their AFLAC rep and have that discussion about the policy.
So AFLAC is our third-party claims administrator, but we definitely would not recommend someone canceling their AFLAC policy simply because Connecticut paid leave is administered through AFLAC. As Kathy said, they might want to look at it, but it's not meant to necessarily replace any policy that they might already have.
Correct. And most of the policies that employees have through AFLAC are individual policies. So they really need to talk to their rep, or I'm sure there's a 1-800 number for those AFLAC policies, and they need to get the information and then, make the decision themselves as to whether or not that's something they would like to continue.
Okay, next question is, does the job protection under Connecticut FMLA also cover benefits protection, or will folks have to go on COBRA?
So currently under FMLA and Connecticut FMLA, employers are required to provide the health benefits. So if someone, let's say, it's not COBRA, it's whatever they're currently paying and what they currently have under benefits. So that doesn't change. That's, that has remained the same. I'm not sure if there's more to the question.
I believe, Kathy, the answer is, and again, this is an FMLA question, so we would advise that you check with the Department of Labor on their website. But I believe you can either continue to pay for your employees' benefits while they're out, or you can have them pay, or you can pay and then you can basically kind of like bill them once they return to work for those benefits. That's my understanding.
That is correct. It's usually, because there's an employer section, employer paid amount, and an employee paid amount. And some, having worked in HR, sometimes we have employees mail us the payment for their health insurance, or they make arrangements when they come back to work for payroll deductions.
Last open question is, what if the company offers 4 weeks paid parental leave? Would Connecticut paid leave kick in after the 4 weeks, or would we supplement the difference to top up to 100%?
Well, it depends on their policy. Does the policy say they have to pay that their policy is we pay 4 weeks. I think it depends on how their policy is written, so that Connecticut paid leave would be paid accordingly.
Right. So from the way this question is written, it appears that they're saying their company offers 4 weeks of paid parental leave.
Mhm.
So I think if the company offers 4 weeks, but then after that they offer nothing else, then Connecticut paid leave
Yes,
would kick in after the 4 weeks
correct,
for up to an additional 8 to be the 12 maximum.
correct.
Okay, I don't see any other open questions. I hope that you found that helpful and informative. Just as a note, if you look on our website, ctpaidleave.org, and you look on the events tab, you'll see all the different webinars that we have scheduled over the next couple of months. We do have some that are specifically for workers. So if you have employees who have been asking questions or who have let you know that they may need to apply for leave in the future, you can certainly advise them to join one of those webinars. Or if you would like to see this information again or have someone else on your team join, we have, I think, 30 more webinars scheduled between now and the end of May. So we would welcome you to join us at any time in the future. Thanks again so much. You will receive a link to the recording and a copy of the deck within a couple of days. And if any questions come up in the meantime, please do use the Contact Us feature and we'd be happy to help you. Thanks so much, everyone. Thank you, Kathy.
All right, thank you. Thank you, everyone. Bye.